Good morning, and thank you for the opportunity to address you today. As medical professionals in Queensland, you play a vital role in delivering high-quality healthcare, but this responsibility comes with growing legal burdens, particularly in the area of medical negligence. Today, I will focus on two critical issues within medical negligence liability: the duty to warn and causation and diagnosis and treatment, areas that directly impact your daily practice. The duty to warn requires doctors to disclose material risks associated with treatment, allowing patients to make informed decisions about their care. Causation, on the other hand, involves proving that a doctor's breach in diagnosis or treatment led to the harm suffered by the patient. These duties, while designed to protect patient rights, often lead to defensive medical practices where doctors make decisions motivated more by the fear of litigation than by medical evidence. This issue is particularly pressing, as defensive medical practices have led to increased test ordering by 55% and referrals by 43% amongst Australian doctors, inflating healthcare costs and exposing patients to unnecessary risks. Examples include the overuse of caesarean sections and diagnostic radiation, both of which carry their own significant health risks. Beyond the financial and health implications, these practices take a toll on doctors' mental health and job satisfaction, with many considering reducing their hours or leaving the profession due to the stress caused by medico-legal pressures. The central argument of my presentation is that while the law aims to protect patients, it places an excessive burden on doctors, pushing them towards defensive practices that undermine the quality of care. I will begin by analysing the legal framework governing the duty to warn and causation, assess whether this framework balances patient protection with support for doctors, and conclude by proposing reforms to alleviate legal pressures while maintaining patient rights. These reforms will focus on adopting no-fault compensation schemes and safe harbor provisions for doctors adhering to recognized clinical guidelines. To begin, we must discuss the state of medical liability, which brings us to our first section, duty of care. Under the Civil Liability Act 2003, also called the CLA, medical practitioners owe a duty of care to patients, covering diagnosis, treatment, and information provisions. Section 9(1)(a) requires doctors to take reasonable precautions against foreseeable risks. Rogers and Whittaker established that doctors must inform patients of material risks associated with treatments. A risk is material if a reasonable person in the patient's position would likely find it significant, or if the doctor knows the patient would regard it as such. This case prioritizes patient autonomy by emphasizing informed consent. Section 21 of the CLA reinforces this duty, requiring doctors to provide sufficient information for patients to make informed decisions. While aimed at empowering patients, the broad application of this section imposes a significant burden on doctors, who must disclose all material risks even when such information might overwhelm the patient. Though the explanatory memorandum for the CLA emphasizes the importance of patient autonomy, the complexity of balancing this duty with patient comprehension can complicate effective communication. Moreover, the Health Practitioner Regulation National Law for Queensland and Good Medical Practice Guidelines reiterate the importance of patient-centered care, where doctors must ensure that informed consent is both valid and voluntary. However, in practice, the extent of disclosure required can challenge doctors in maintaining clear, comprehensible communication while meeting legal expectations. This brings us to our next topic, breach of duty. Breach occurs when a doctor's conduct falls below the expected standard. Section 9(1)(c) of the CLA assesses breach based on the likelihood and seriousness of harm, alongside the burden of taking precautions. Traditionally, the Bolam test, stemming from Bolam and Frian Hospital Management Committee, allowed reliance on a body of medical opinion, but Rogers and Whittaker rejected this in failure to warn cases, shifting the assessment of risk to the courts. While Section 22 of the CLA allows doctors to rely on peer professional opinion as a defense, Section 22, subsection 5, excludes this in failure to warn cases. This exclusion places additional pressure on doctors, forcing them to second-guess their medical judgment, particularly in high-risk situations. In State of Queensland and Mason, the High Court reiterated that negligence is ultimately a judicial determination, underscoring the vulnerability doctors face even when following accepted medical standards. This exclusion undermines the role of medical expertise in legal proceedings, pushing doctors to adopt overly cautious approaches that may detract from patient care. While the good medical practice standards advocate for shared decision-making, the absence of the peer professional defense in failure to warn cases leaves doctors unsure of where medical judgment ends and legal liability begins. Cases such as Battersby v. Tottenham highlight the court's reluctance to accept therapeutic privilege, which is the right to withhold information to avoid harm to the patient, as a justification for failure to warn, further limiting the protection offered to doctors. This leads us to the discussion of causation. Section 11 of the CLA outlines two elements necessary to establish causation, which are factual causation, where the breach must be a necessary condition of the harm, and scope of liability, where it must be appropriate for liability to extend to the harm. In Chappell and Hart, the High Court ruled that a doctor's failure to warn would be causally linked to harm if the patient would have chosen alternative treatment. However, in Wallace and Cam, the High Court clarified that even if there is a breach of duty, causation will not be established unless the harm falls within the scope of the risk the duty to warn was intended to protect against. If a patient would have undergone the treatment regardless of being warned, or if the harm suffered was unrelated to the risk, then causation may not be found. Section 11, subsection 3 adds further complexity, requiring courts to consider whether the patient would have undergone the procedure even if they had been warned of the risks. This provision introduces significant uncertainty, as it hinges on reconstructing the patient's decision-making process. The High Court in Rosenberg and Percival cautioned against the dangers of hindsight bias, emphasizing that courts must avoid relying solely on a patient's testimony about what they would have done. This case underscores the difficulties in proving causation based on hypothetical patient decisions, contributing to a legal environment that encourages defensive practices amongst doctors. Further complementing the issue is the High Court decision in Naxaxis and Western General Hospital, which established that even when multiple factors contribute to an injury, doctors can still be held liable if their breach materially contributed to the harm. While Tibet and Gett rejected the loss of chance doctrine, providing some relief to doctors, the overall burden remains substantial, particularly in failure to warn cases where establishing causation is highly speculative. These legal complexities often push doctors towards defensive practices, as proving what a patient would have done had they been warned remains an inherently uncertain and contested area of the law. Now we must consider the available defenses. Section 22 of the CLA provides doctors with a defense based on peer professional opinion, allowing them to rely on a body of accepted medical practice. However, Section 22 subsection 5 excludes this defense in failure to warn cases, significantly limiting doctors' legal protection. In Medical Board of Australia and Leggett, the court reaffirmed that reliance on professional opinion does not protect doctors if those practices are deemed unreasonable by the courts. This places doctors in a precarious position, where following accepted medical standards does not guarantee protection from negligence claims, particularly in failure to warn situations. Section 24 of the CLA allows for contributory negligence, which reduces damages if a patient's own actions contribute to the harm. However, courts rarely reduce liability in medical negligence cases. For example, in Waller and James, contributory negligence offered minimal protection, demonstrating that a patient's failure to follow medical advice often does little to alleviate doctors' liability. While the CLA includes useful provisions for capping damages and allowing apologies without admitting liability, these measures do little to address the broader legal risks doctors face, particularly in failure to warn cases. The high stakes and uncertainty associated with causation and defenses in medical negligence law push doctors towards defensive medical practices where legal concerns take precedence over optimal patient care. As this outcome is not desirable, we must now critique the state of medical liability. Queensland's negligence law, particularly the duty to warn under Rogers and Whittaker in Section 21 of the CLA, places a heavy burden on doctors. While designed to ensure patient autonomy through full disclosure of material risks, the law often results in overwhelming patients with excessive information, potentially confusing them and compromising their decision-making. In practice, this undermines the very autonomy the law seeks to protect, as doctors are required to warn of all risks, even those not clinically significant, which can divert attention from more important aspects of care. The exclusion of peer professional opinion in failure to warn cases under Section 22 subsection 5 compounds this issue. By sidelining medical expertise, the law leaves doctors vulnerable to legal claims, even when their judgment aligns with professional standards. This creates an environment of uncertainty that drives defensive medicine, where doctors are more focused on avoiding litigation than on patient-centered care. The resulting overuse of tests and procedures escalates healthcare costs without necessarily improving patient outcomes. In terms of causation and diagnosis and treatment, Section 11 of the CLA sets stringent requirements for establishing a causal link between a doctor's breach and the patient's harm. Proving that a patient's harm directly resulted from a doctor's failure to warn or an error in diagnosis or treatment is often speculative. The additional complexity introduced by Section 11 subsection 3, which requires courts to determine what a patient would have done if properly informed, leads to significant reliance on hindsight, as seen in Rosenberg and Percival. This not only places doctors at a disadvantage, but also perpetuates a defensive approach to care. Although these laws aim to protect patient rights, they disproportionately burden doctors and promote inefficiency within the healthcare system. Defensive practices intended to reduce malpractice risk do not translate into better patient care, but instead inflate costs and strain resources, as seen in other jurisdictions like the US, where it is estimated that 2.8% of the total medical expenditure is due to defensive medicine. In conclusion, while the law seeks to balance patient protection and accountability, it fails to adequately support doctors in practice. The duty to warn, combined with the speculative nature of causation in diagnosis and treatment, creates a system that encourages defensive medicine, undermining the quality of care and driving up healthcare costs. Reform is needed to realign legal standards with the practical realities of medical decision-making, so that is what we will discuss next. Queensland's medical negligence law, particularly in relation to failure to warn and causation in diagnosis and treatment, needs reform to ease legal burdens on doctors while safeguarding patient protection. Amending the CLA is challenging because reforms benefiting doctors often adversely affect patient rights. Reform should focus on areas benefiting both, as doctors' improved working conditions will ultimately enhance patient care. The proposed reforms aim to shift from a strictly fault-based model to one that balances fairness, transparency, and efficiency in resolving medical injury claims. The first reform is a no-fault compensation scheme. Queensland could adopt a no-fault compensation model for medical injuries similar to New Zealand's Accident Compensation Corporation. A no-fault scheme compensates patients without requiring proof of negligence, bypassing adversarial litigation. This would reduce doctors' legal pressures, allowing them to focus more on patient care. A no-fault system moves away from traditional fault-based negligence, which is rooted in corrective justice, compensating only when negligence is proven. Instead, it aligns with distributive justice by providing more equitable access to compensation, recognizing that medical errors often result from complex systemic factors. New Zealand's ACC system illustrates this, offering broader compensation and lower indemnity fees for doctors, fostering a culture of transparency and problem-solving without fear of litigation. The 2011 Productivity Commission report's proposal for a national injury insurance scheme highlights the potential for a no-fault model to address inefficiencies in Queensland's current system, which is slow and costly. While fault-based litigation aims to deter negligence, no-fault systems provide faster resolutions and reduce the social cost of injuries. This shift from a fault-based deterrence to a focus on systemic efficiency and fairness benefits both doctors and patients and the healthcare system. This leads us to the second idea for reform, safe harbor provisions. If a no-fault scheme is too drastic, these provisions could provide a milder alternative. Theoretically, these would protect doctors who adhere to recognized clinical practice guidelines from negligence claims unless the guidelines are proven irrational. Safe harbors offer more certainty than the peer professional defense under the CLA, reducing litigation risks while promoting consistent patient care. Safe harbors shift the focus from finding fault to ensuring doctors follow evidence-based practices, aligning with utilitarian tort theories that prioritize social welfare and the efficient functioning of healthcare. Although they have rarely been implemented outside of limited trials in America, the concept is intriguing, and in Queensland, this reform could provide legal certainty for doctors, encouraging adherence to best practices while maintaining accountability for significant omissions. These reforms reflect a move away from the adversarial nature of negligence claims towards a more balanced, patient-centered approach. A no-fault system would promote faster resolutions and transparency, while safe harbors would reduce legal risks and encourage adherence to evidence-based practices. Both reforms aim to reduce litigation, benefiting doctors and patients alike. To conclude, Queensland's current medical negligence law places disproportionate burdens on doctors, particularly in failure to warn and causation cases. While the law aims to protect patient autonomy, it has led to defensive medical practices, inflated costs, and weakened doctor-patient relationships. The proposed reforms, introducing safe harbor provisions and considering a no-fault compensation scheme, would alleviate these pressures while challenging a traditional fault-based tort principle. no-fault scheme grounded in distributive justice would simplify compensation and promote transparency, benefiting both doctors and patients. Safe harbors, in contrast, would offer legal certainty while promoting adherence to evidence-based guidelines, balancing fairness with medical realities. These reforms offer a more balanced approach to medical negligence law, shifting the focus from blame to efficiency and patient-centered care. By reducing legal risks and promoting transparency, Queensland's negligence framework could better support high-quality healthcare and legal fairness.